we have an article here from 20th of June 2024, Eileen Watson. It says, Court misapplied the law in Evian carbon neutral ruling, says Danone Waters. Article begins, Danone Waters of America has urged a court in New York to reconsider its recent decision to allow a lawsuit over allegedly misleading carbon neutral claims on Evian bottled water to proceed. Regulatory affairs experts are closely watching the case amid growing scrutiny of carbon neutral claims, while some large CPG players are reportedly souring on the term. In this case, the claim was certified by a high-profile third party, the Carbon Trust. In his January 10th order, U.S. District Judge Nelson S. Román said it was plausible that the ambiguous term carbon neutral, a technical word not within an average consumer's common parlance, and carrying multiple meanings, could mislead a reasonable consumer. Were Evian to have used the term to induce consumers to purchase the product at a higher price, he added, the plaintiffs had also plausibly pled a fraud claim. In a motion urging the judge to reconsider, Danone said the court had focused on the statement carbon neutral, which it found ambiguous, instead of the fully contextualized statement on the back of the pack, "We are certified carbon neutral," next to the Carbon Trust logo. It added, that full statement beside the Carbon Trust logo is not ambiguous. It communicates the existence of a certification. As another court recently held in an analogous case where the defendant's label said certified sustainability source, the defendant is not advertising that their products are sustainable, but that their products are certified as sustainable. This is a distinction with a difference, and that label is not a lie. According to Danone, Judge Román had also misapplied the law in sustaining the fraud claim, both with regard to fraudulent intent and to whether a false statement of fact had been pled. It added, allowing the fraud claim to proceed is particularly improper and would create dangerous precedent. Simply parroting the word greenwashing to clear the high bar for pleading scienter, intent to defraud, and claiming the company seeks to increase demand and charge a higher price does not comport with Second Circuit law, which requires motive and opportunity to be alleged with allegations that are not shared by all profit-making enterprises. The case is Stephanie Doris et al. Versus Danone Waters of America, filed in the Southern District of New York. Case 7-22-CV-08717. End of article. So this is an interesting update, another legal news article here. It's a lot of legalese about Carbon Trust, brand positioning, branding, certification, certified as carbon neutral, what exactly the third party, the Carbon Trust, serves. Are they some sort of global nonprofit authority? Are they some sort of association? Do they even have jurisdiction? So I think the legal case here is basically Danone Waters is saying that the rather ambiguous carbon neutral that is on the front of the bottle is backed up by a third party, meaning the Carbon Trust, having said that they are certified to be carbon neutral according to the Carbon Trust, and so that's really the legal case there. And so if there was motive and opportunity, and then maybe they're claiming the plaintiffs in the case that that justifies a higher price, and then the consumer is now basically forced to or misled to purchase this water at a higher price because it's got this extra certification as carbon neutral, that might be misleading or fraudulent. So that's the legal case. It's an interesting article, and looking forward to seeing with a future update how this court case is carried out and concluded. Let's see.